Hello, America. I'm Mark Levin, and this is Life, Liberty, and Levin Saturday. We have two great guests, Senator Ted Cruz and Hans von Spakovsky of the Heritage Foundation. But before we get to them, well, birthright citizenship is back because the Supreme Court's going to take this up in earnest. And if they take it up in earnest, it's a slam dunk case against birthright citizenship. My great fear is, having experienced the aftermath of the Dobbs decision, where marauders were hanging out around their homes and tracking them to vacation spots, using loud sound devices and so forth to keep them up at night with really no help from the Biden regime and their Department of Justice. They may not want to face that again because they know if they uphold birthright citizenship that you and me, we don't do that kind of thing. On the left, they do it for a living. I hope that's not the case. I hope they will actually apply the Constitution in the context of everything that's taken place like they're supposed to. I hope they'll uphold the Constitution or maybe cut the baby in half, so to speak. That is, going forward, birthright citizenship is a non-constitutional matter. That is, it is unconstitutional, but we will grandfather in those who've already received it. I don't know, but the worst thing that they could do is just pretend that the Constitution confers birthright citizenship on the children of illegal aliens. There's already been efforts, even by some of my friends in the legal community, some professors, to make the case. It's very weak, but if the Supreme Court wants to go there, they'll figure out how to go there, like they did with the Obamacare decision, which was an abomination, or which they did with the Dred Scott decision in the 1850s, which was an abomination. But there's always hope. But I want to help those Supreme Court justices who might be watching, but you, Mr. and Mrs. America in particular. First, let's set the stage. The Civil War is over. It's 1865. And so Congress gets together and they think we need to make some amendments to the Constitution to ensure that the rights and the liberties and the protections that are afforded to all Americans are afforded to newly freed black slaves and their children. That was the focus. They weren't focused on immigration at all, legal or illegal. It had nothing to do with it. You just ended the worst war in American history. You had 700,000 casualties. The Ku Klux Klan is running loose in the South. You've got Andrew Johnson, the president of the United States, who's being impeached. You've got all kinds of things going on. The idea that immigration, let alone illegal immigration, let alone citizenship for the children of illegal immigrants, was at front of mind, that was on their mind at all, is absurd. It's preposterous. So I want you to remember this. They were concerned the 13th Amendment ended slavery formally. The 14th Amendment ensured that all states would treat freed black slaves and their children as American citizens for all purposes. The 15th Amendment was intended to assure that free black slaves and all blacks would receive their civil liberties, among other things. This was the Reconstruction period after the Civil War. No attention to immigration, legal, illegal, let alone the children of illegal immigrants. To suggest that the language in the 14th Amendment, as I will prove yet again, was intended to apply to children born of illegal immigrants, where they could basically have jurisdiction by their own decision, come into the country illegally, say, I've created jurisdiction for my child, my will-be child, is so absurd. So absurd. That's not what they did. So now the question is, to what extent might the Supreme Court twist the language in the 14th Amendment to accommodate the practices that take place today that are utterly unconstitutional? Let's take a look at this. First, I see there's some arguments on the other side that there's never been anything like illegal immigration. Oh, there's never been illegal immigration. That's why you never had them address the issue before of illegal immigrants and illegal immigrant children. Well, that's flat out wrong. I spent a lot of time on this. Let's take a look at this. The states had a lot of say in immigration in the early part of our country and even before our country in the colonies when there weren't states. 1639, colonial Massachusetts law authorized towns to remove poor people who had no legal settlement in the town, no legal authority to be there. 1683, colonial New York, the law authorized local officials to send transient beggars to the country from where they came. 1794, Massachusetts state law allowed for the expulsion of any pauper without legal settlement in the state to any other state or to any place beyond the sea where he belongs, quote unquote. 1798, the Alien Act authorized the President of the United States to arrest and deport foreign nationals whom he deemed dangerous to the peace and security of the United States. 1850, Massachusetts immigration officials were authorized to deport foreign paupers from the United States. So there were distinctions made. You were deporting people who were doing what state or local law determined was illegal. Out. Illegal immigrants. Out. But here's a different one, a bigger one, a federal one. The Nationality Act of 1790. You're not going to know more than virtually anybody else. This is very, very important. Nationality Act of 1790. Now, in many respects, it was a grotesque law. It was. It talked about free white people and so forth, but that's not my focus on this. My focus on this, again, is historical precedential. It's the law. What did we do in 1790? Well, anybody who shall have resided within the limits and under the jurisdiction of the United States for the term of 2 years may be admitted to become a citizen thereof on application to any common law court of record in any one of the states wherein he shall have resided for the term of 1 year at least, and making proof to the satisfaction of such court that he is a person of good character, and taking the oath or affirmation prescribed by law to support the Constitution of the United States, which oath or affirmation such court shall administer, and the clerk of such court shall record such application, and the proceedings thereon, and thereupon such person shall be considered as a citizen of the United States. There were citizenship laws. There's a federal one, 1790. And the children of such person, so naturalized, dwelling within the United States, being under the age of 21 years at the time of such naturalization, shall also be considered as citizens of the United States. So what does this say? Why am I wasting time with the 1790 Naturalization Act? Because it's crucial. You must have affirmative steps. There are affirmative requirements. No automatic citizenship for a parent or child. Affirmative requirements to go to a court. You must be a person in good standing and so forth and so on. You couldn't just come to the United States, have a child, and say, well, my child's a citizen. Well, there was no 14th Amendment. But those who argue against my position, our position, claim that there was no such thing as illegal immigration. Of course there was. I just read it to you in 1790. Obviously, this would apply to the birth of a child of an illegal alien. An illegal alien being somebody who didn't go through this process or didn't succeed when they went through this process. That's the Nationality Act of 1790. Very, very important. But let's go now, which was pretty much the law with amendments and some changes here and there, right up to 1866. What happened in 1866, the year after the end of the Civil War? Congress passed the first Civil Rights Act in American history. Republicans pass all the Civil Rights Acts in this country, just so you know. Civil Rights Act in 1866. It was drafted by Senator Lyman Trumbull. Who was he? He was an attorney, he was an abolitionist, he was a Republican, a very active abolitionist when he was in the United States Senate. The Civil Rights Act of 1866, in relevant parts, said, be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States, not subject to any foreign power. So jurisdiction, you see, ladies and gentlemen, when you even look at the 1866 Civil Rights Act, what did it mean? Did it mean physical jurisdiction, geographic jurisdiction? No. It meant political, legal jurisdiction, that you had an allegiance to one country and only one country. Andrew Johnson vetoed the 1866 Civil Rights Act. Why did they pass this Civil Rights Act in 1866? To protect freed black slaves and their children. That was the entire focus. Not on people from Bolivia, not on people from Egypt, not on people from Russia. They were dealing with what was taking place in the United States. Andrew Johnson vetoed it. Congress overrode his veto, but the concern was it was a statute, and they decided that they were going to amend the Constitution, and they were going to use the language, alter it slightly, but apply the basic fundamental language and arguments of the 1866 Civil Rights Act to a new amendment to the Constitution. This would be the 14th Amendment to the Constitution. Now, the citizenship clause of the 14th Amendment that we're focused on right now, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, we know what they meant by the jurisdiction. They meant that no foreign country has any kind of jurisdiction over them. If you're an illegal alien in the United States, you remain a citizen of the country from which you came. And I'm going to get into that more in a moment, which is just rational. You haven't gone through the process of being a naturalized citizen. You weren't born in the United States. But what about a child? We'll get there in a second. So that's the language of the 14th Amendment. And people are saying, well, jurisdiction obviously means they're here, they had a baby, therefore it's in the United States, and that's that. No, that's not, that's that. 1866, Senator Jacob Howard explained that the clause, he was one of the authors of the amendment, was, quote, simply declaratory of the laws of the land already, that here's a quote, every person born within the limits of the United States and subject to their jurisdiction is by virtue of natural law and national law a citizen of the United States. So what is he saying there? Simply declaratory of the law of the land already. What was the law of the land already? The 1866 Civil Rights Act. That was the law. Passed over Johnson's veto. The law was there could be no foreign jurisdiction of any kind. And the three remaining authors of the act, John Bingham and Thaddeus Stevens, Senator Trumbull again, who was involved in the 1866 Civil Rights Act, he argued during the debate over the proposed 14th Amendment that subject to jurisdiction of the United States meant, quote, not owing allegiance to anybody else, unquote. I don't know how else they can say it. I don't know how else they can say it. They said it in the negative. They said it in the affirmative. They said it in the Civil Rights Act of 1866. There it is in black and white, plain English, the text, the 14th Amendment. So you have to do somersaults in order to say, but by jurisdiction, all they really meant was in the United States. Clearly, that's not what they meant. The 14th Amendment, to underscore, citizenship clause was exclusively addressing free black slaves and their children. It has nothing whatsoever to do with illegal aliens. Never did. In fact, I can find no evidence at all that any of these key members of Congress who worked on the draft ever uttered the words illegal aliens, illegal foreigners, aliens from other countries, undocumented people. Never came up. As you can imagine, as I explained, there was turmoil going on. The country was still reeling from the end of the Civil War. The Klan was on the move. They were impeaching Johnson, or were preparing to. There was a lot going on, and the furthest thing from their mind was, well, what about children of illegal aliens? As I mentioned earlier, Mexico And every other country from where an illegal alien comes, they view illegal aliens in our country as citizens in their country. They do not accept the interpretation that those who claim birthright citizenship exists. They do not accept that interpretation. They consider a child born in our country from foreigners who are in the United States illegally to be citizens of their country, which underscores the whole point, does it not? Everyone agrees that diplomats and tourists or others who are in our country, traveling through our country here temporarily, they have babies in our country, that those children are not subject to the jurisdiction of the United States under the 14th Amendment. Why? Why does everybody agree to that? Because under the theory and arguments of those who argue for birthright citizenship, where's this exclusion in the Constitution? Where's this exclusion anywhere? It doesn't exist, and yet they insist on it. If the 14th Amendment applies only to physical presence in our country and not to political and legal allegiance to our country and only our country, how can you carve out these exceptions or any exceptions? They just do it. The United States versus Wong Kim Ark decision in 1898, people point to this as precedent, as stare decisis. It has absolutely nothing to do with the debate over the children of illegal aliens and birthright citizenship in that context. Zero. Zero. In that case, the citizenry of the child at issue had to do with a child of legal foreign residence. Hello, legal foreign residents in the United States. No illegal aliens. Even so, that case was not correctly decided because the parents, and therefore the child, still had legal status in China. And China still recognized their legal status in China and their allegiance to China. But you know what, Supreme Court justices? Just ignore the case. You can entertain it if you really want to, but if you entertain it, you'll come out as I do, if you do it legitimately. But if you try and twist it and turn it and pretend it has something to do with the right of birthright citizenship, you're going to be viewed as activists, radical activists. The Supreme Court should consider overruling it, but better yet, just reject it as any kind of precedent under stare decisis, because it's no precedent whatsoever. So these are the facts. And we're going to bring in a friend of ours, Hans von Spakovsky, to see what he can add to this. He's litigated in this area. He's an expert in this area. We've talked to him before about this. But again, there are now some very weak efforts, but efforts that the media love, where we have some professors, some other lawyers who are out there saying this is really a slam dunk for birthright citizenship. Oh, one other thing, a footnote. British common law. Without doing a whole course on this, they're now saying, well, British common law recognized that the birth of a child to alien or illegal alien parents in the British Commonwealth on the territory, on the land, was viewed as citizenship. And you know, during the early parts of America, they relied very heavily on British common law. No, they didn't. In fact, in many respects, they wanted nothing to do with British common law. They certainly didn't rely on British common law when it came to immigration. We'll be right back.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.